accommodations in the United States. This isn't the first time that we've done public accommodations in this class. If you think back to the Civil Rights Act of 1875, you'll remember that one of the first attempts to enforce that was in sort of these public accommodations. So what are these public accommodations more generally? Well, these are any sort of public area, beaches, parks, buses, you can see courtrooms. All these things are considered public accommodations because they supply services to the general public. Another way, using the language of the time, would be to think of these as essential businesses. So clearly restaurants, hotels, buses, parks, beaches, all of these are sort of essential businesses. So what else would be folded into this in terms of the Civil Rights Act of 1964? Pools, any theaters, those things that provide generalized services to the public are all folded under this. Now, if you remember, Harlan's dissent regarding the Civil Rights Act of 1965 was that, well, at least in part, in the future, individuals might be able to enforce these types of laws, not via the 14th Amendment, but instead via the Commerce Clause. And so the Civil Rights Act of 1964 is passed, but it's done entirely on the back of the Interstate Commerce Clause as its justification. Well, what does the Interstate Commerce Clause say? Well, it says that the federal government has the exclusive authority to regulate interstate commerce. So the question then falls to, what is interstate commerce? Those of you who took my constitutional law class, we do a very long section at the end of that class about what is interstate commerce. In fact, the last third of the class is entirely interstate commerce. Here we sort of dip our toes into it to talk about the Civil Rights Act of 1964. So interstate commerce, technically, in the technical definition, not necessarily where the court takes it eventually, but interstate commerce is any sort of commerce that, by its nature, involves multiple states. So when we think about these things that we call public accommodations, restaurants, hotels, courtrooms, buses, parks, beaches, there all is an element of travel or commerce to them. So for example, hotels, as we'll see in the next case, Heart of Atlanta, individuals travel to hotels. Hotels are part of the flow of commerce, the commerce itself being the individuals moving. Restaurants, to the same function, provide food to individuals who are moving or individuals who are eating at home, same with buses, parks, and so on and so forth. And so in this regard, the federal government is reaching down to these sort of public accommodations and arguing that since we have the authority to regulate interstate commerce, what we can also do is regulate the practices of businesses that are engaged in the action or in the chain of commerce. This case that we're going to do next, Heart of Atlanta Motel, is very clearly involved in interstate commerce. And the case goes to extensive lengths of describing how connected that interstate commerce is. But I want you to, those of you who haven't taken con law with me, to understand is that in the wake of the Civil Rights Act of 1964, the definition of commerce gets much broader. There's a case that I can give you an example of without remembering the name of it off the top of my head. There's a barbecue place in Texas, and this happens in the 1970s. There's a barbecue place in Texas that gets all of its meat locally within Texas, gets all of its seasoning locally within Texas, is not on a main highway, so there's not a lot of travel. It almost serves exclusively a local clientele. And the Supreme Court in that case says ultimately, no, all of that, it's still commerce because it's involved in the flow of commerce. Even if it is entirely local in nature, it still brushes upon interstate commerce. So following Heart of Atlanta Motel, the definition of interstate commerce gets significantly broader. So let's go ahead and do Heart of Atlanta. So let me, again, switch over to my notes. There we go. So the Heart of Atlanta Motel, not shockingly, was in Atlanta. And on top of it simply being in Atlanta, it served a significant amount of travel. Like the individuals who were involved in this case, the hotel itself, um, did business almost exclusively for individuals who were traveling. So Title II of the Civil Rights Act of 1964 forbids racial discrimination um, in all sorts of public accommodations if their operations affect commerce. In this case, the Heart of Atlanta Motel um, exclusively uh, served white clientele. They refused to serve African Americans. And so the federal government brought suit under the Title II of the Civil Rights Act of 1964, saying that he was simply in violation. The owner of the hotel countersued and said that the law itself, Civil Rights Act of 1964, was a violation of interstate commerce. And he also made a couple other claims. And I include them here not because they're decisive in the outcome, but because they are a significant degree of bravado. First, he also claimed that this law violated the Fifth Amendment's due process clause. And he also claimed that it violated the 13th Amendment's prohibition upon indentured servitude. I'll answer those right off the bat. There was no way possible, and the court deals with this at some length, but I'll deal with it much quicker. There was no question that the Fifth Amendment due process clause was not infringed by the Civil Rights Act of 1964. And here's how I can tell you that. He ended up getting his case before the United States Supreme Court. Due process means you don't get to challenge the decisions. He's very clearly challenging this decision. So the Fifth Amendment due process claim was immediately thrown. The 13th Amendment towards indentured servitude, prohibition on indentured servitude and slavery more generally, was also similarly done away with very quickly because there was no slavery involved here. Because, as many of you may know, slaves aren't paid. He was still allowed to charge his customers for them staying at the hotel and was going to make profit off of it. That seems to be a definitional problem. So the only issue that we want to deal with for the purposes of this course is, does Title II of the Civil Rights Act run afoul of the Commerce Clause in denying motel owners the right to choose their own customers? So this case, considering the time, it should not shock you that this case was unanimous. Justice Clark writes the majority opinion and says that the government absolutely can enjoin hotels from discriminating on the basis of race via the Commerce Clause. In fact, very particularly, he points directly to the Commerce Clause as the means by which states, or that the federal government can actually choose to do this. He focuses at some length in the opinion upon the nature of business of the Heart of Atlanta Motel. 75% of the hotel's business comes from out of state. So 75% of its clientele were from out of state. Now, if the definition of interstate commerce is engaging in commerce that crosses two state boundaries, or a state boundary, and 75% of your clients come from out of the state, then you were engaged in an act of interstate commerce by providing them services that they would not need unless they were from out of state. Then obviously you're engaged in interstate commerce. And there is no question that the federal Constitution empowers the government to regulate interstate commerce. And in this case, in the Civil Rights Act of 1964, they're very clearly regulating interstate commerce. Furthermore, the hotel was positioned at the intersection of two major interstate highways. Interstate, obviously, being the important term here. Because of that flow of traffic, that interstate traffic, There was no question that this hotel in particular was providing a public accommodation for interstate travelers. Um, so the takeaway of this case is that if you were providing a public accommodation that was closely aligned to interstate commerce, then absolutely the Civil Rights Act um, and the government's enforcement could prohibit you from discriminating on the basis of race of customers. This gets broadened over time, but the general tenor of this decision moves forward unimpeded. And this is really the major victory for the Civil Rights Act of 1964, because now the federal government isn't just involved in making sure schools are racially desegregated. They're actually into businesses, making sure that businesses aren't discriminating on the basis of race and ethnicity.